And the next panel is called Talk to My Lawyer. Every element of internet radio ad serving, user privacy, copyright royalties has often complicated legal issues to consider. I think everyone that's grown up in this industry is aware of the different legal harangues that we've been through, and a lot of them have been settled, but there are still some that are unsettled. The experts on our next panel will shed some light on the issues and hopefully some of the settled issues as well. Tom Taylor will moderate the panel. Tom says he grew up in a radio station and programmed a number of them, including WPST in Trenton. Then he became a journalist who covers the industry, and he's now the executive news editor of radioinfo.com. I think most of us probably know that because we probably read that on a daily basis, based here in Chicago. And he writes the daily newsletter named TRI. Please welcome Tom Taylor. You're welcome.
Well, we have no ninjas. I don't think we have any nurses. And what was the other one? We had nerds. So if the panelists want to come up, we have 3 of those. They're not nerds. We have 3 panelists, 4 chairs, so pick a chair that you like. That's Angus coming up. That's Colin. I want you to know that Colin, and that's David Oxenford, Colin has the best email for an attorney I've ever heard in my life. It's C rushing, which is what? Crushing. How's that for an email for an attorney? Pretty good. And you wanted it, right?
I think it says something about what he does, you know.
Okay, we'll get into that. All right, okay. Sometimes talk to my lawyer is said in a less than friendly way. Today we have 3 friendly counselors at law. We got 20 minutes. We're going to talk about a number of areas. I want to ask each of them basically one question. Keep going back and forth. At the end, if you got questions, please ask, and also know that the party, and by the way, always trust Kurt Hansen to buy pizza for you. Kurt knows where to buy pizza in this town. The party, I think they'll all be around. So if there's something that's in your brain that you want to talk about later, call any one of these folks and they'll be happy to talk. So first, royalties. Colin Rushing, General Counsel of Sound Exchange, overseeing legal, regulatory, and corporate efforts, supervising rate-setting proceedings, and directing enforcement. So before Soundex, Colin worked at the Wilmer Hale Law Firm. And Colin, we all deal with Sound Exchange. Can you explain it just very schematically, very quickly, what Sound Exchange does?
Sure. So I think probably most of the people in this room know at a high level what Sound Exchange does. We collect the royalties that anybody who does basically internet radio, anybody who uses the statutory license for non-interactive digital audio transmissions, they have the option of paying Sound Exchange to cover the royalties that they owe to record labels and other copyright owners of those sound recordings. Now, there are 3 points that I sort of want to emphasize about Sound Exchange. We're obviously complicated in our relationship with services. There's a number of different levels, but there are 3 basic points that I want to leave you with. One, if it wasn't for Sound Exchange and the statutory license, there would still be an obligation to go out and actually get licenses, that is, get permission from all of the record labels and other copyright owners of the sound recording. So what you get with Sound Exchange is a true one-stop shop. You send us 1 check every month and the reporting, and that covers your obligation for 100% of the commercially released sound recordings that you are using on your internet radio services. The second point I want to leave you with is, and not a lot of people in this room may know this, Sound Exchange is unique in the sound recording business in this way. We collect performance royalties. They are owed for the use of the sound recordings. The sound recordings are owned by the copyright owner, which is typically a record label. Notwithstanding that, fully half of the performance royalties that we collect goes directly to the artists themselves. So even if the artist is under contract with their record label, even if they still owe money to the record label in the form under their contract, we still send half of the performance royalties directly to the artists. And the third point, and this is something that we're really happy about, the rates that exist now go through 2015. The huge majority of the services that use the Sound Exchange license are operating under rates that were negotiated with webcasters. These are negotiated rates. I think it's ushered in a period of rate stability. We can have differences of opinions about the rates themselves, but
That'll be in 2 guests from now.
But one of the things that we've seen is when we go to these panels, we're not talking about rate disputes and what's going to happen. There's certainty about what the rates are, and people are building businesses around those rates, and we're working with services as business partners, and it's a role that we really relish.
David Oxenford.
Let me just jump in for 1 second, because Colin is a really nice guy. He's a neighbor. I mean, I've seen the guy in his bike shorts, which is really an exciting thing to see. But you have to remember that even though the rates are set through 2015, after 2015, we don't know what they're going to be. And there's going to be a fight, probably again in 2015, as to what those rates should be. So we all should be thinking about now the strategy that's going to be employed at that point, because I can guarantee you, Colin and all my other friends at Sound Exchange are thinking about what they're going to be doing for the royalties in 2016.
Let me mention that David is a partner in the D.C. office of Davis Wright Tremaine. He has 30 years of experience representing broadcasters and the FCC and other places. He's also worked with webcasters, including Live 365, for the past 10 years. And he's the principal author of the Broadcast Law blog, which I heartily recommend to you. I check it every day as a journalist. David, you want to say any more there, or should we go over to the gentleman to your left? Angus?
Well,
Live 365.
So Colin's absolutely correct. There is a certain level of stability in the sound recording rates, but there's still quite a minefield of potential royalty issues that still exist for webcasters like Live 365. I'll just focus on a few that I'm working on. One is international. I heard Kurt talk earlier about global opportunities for webcasters. Just keep in mind, while there are opportunities, there's also potential royalty obligations. So if you're a webcaster and you're not geo-blocking, and so that means you're streaming wherever, there's a good chance as you get bigger, the foreign performance rights organizations are going to be contacting you in the very near future. So just keep that in mind if you're thinking about expanding globally, or if you're already global. Another thing is that so Colin's organization deals with the sound recording rights. ASCAP, BMI, and CSAC, they deal with the music composition rights. And there was a recent development that occurred a few months ago about EMI withdrawing one of its major publishing catalogs from ASCAP, at least with respect to digital licensing. And what that's effectively created is another PRO that you got to deal with in terms of getting a license with. So you got to go with ASCAP, you got to get BMI license, you got to get a CSAC license, then now you got to get an EMI license. And if other of the major record labels do something similar, basically withdrawing from the major PROs, then you're going to have to get licenses from all of them as well, Sony, Warner, Universal. So that just creates additional complexities for webcasters to make sure that they are properly licensed.
Yeah, there's one other thing that we ought to jump in on here. Colin made a good point that he covers through Sound Exchange non-interactive webcasting, and that's basically a radio type service where the listener can't dictate what they're going to hear next. If you're using music in any other way, you got to get a license directly from both the record labels and the music publishing companies, the guys who hold the rights to the underlying words and music in a song. So if you're podcasting, if you're taking a song and trying to use it in a commercial or a promotional announcement, whether it's on the air, regular broadcast over the air, or whether it's digital, you need to get those rights. It's not covered by ASCAP, BMI, and CSAC, and it's not covered by Sound Exchange. Any sort of on-demand use, got to clear those rights directly.
Should mention that Colin, well, let's go to Colin. We want to talk about a simple question. How do webcasters get in trouble with Sound Exchange?
It's very
often.
What did you say, often? Yeah, I mean, it's pretty easy. It's to ignore their obligations. We have an enforcement program that we've been working on for a couple of years. It continues to expand. It's primarily focused on webcasters that we identify, that we figure out are completely blowing off their obligation to get a license. We think that is bad for the artists and the copyright owners, and it's also bad for the services that are playing by the rules. One of the things that we successfully did last spring is we convinced an ISP to take down one webcaster that was continuously and willfully ignoring our demands that they just do what they're supposed to do, which is get a license for the sound recordings that they're transmitting. That is where our sort of capital E enforcement efforts are focused. In terms of webcasters that are trying to do the right thing, we do everything we can to help them navigate the paperwork and the forms and the reporting obligations. There's frankly room for improvement there. I mean, we know, that we want the system to be as user-friendly as possible, consistent with the regulations. That effort is also within my shop, and it's a lot of the same people that do the enforcement work also do this sort of what I think of as more licensee relations work. But for those folks, we really do try to be helpful, and we answer questions from webcasters all the time and every day.
I want to ask one more question, and then maybe Paul can grab a microphone. Anybody got any questions? So just think about a question if you got one. Angus, last month, big board decision about MP3 tunes. What was that about?
Yeah, when I actually spoke about 5 months ago at a RAIN panel in Vegas, Amazon and Google just launched their cloud-based storage service, and there was some questions about the legality, and I talked about the potential legal armor that Amazon and Google had with respect to their cloud-based storage service. But I said that it'll be interesting to see what happens with the MP3 tunes case, and that decision just came out 3 weeks ago. And it's formidable armor for cloud-based storage services. It's like a Captain America's shield for Google and Amazon, and even other digital music services like Grooveshark. Basically, MP3 Tunes is a cloud-based music locker service, and they were sued by EMI and some of the other publishing companies, and they prevailed in part, but they prevailed on key aspects with respect to the DMCA. And so the key takeaways from the decision is, even though the decision didn't really talk a lot about the legality of a cloud-based music service, it certainly has some very, very, very good language there that cloud-based services can hang their hats on. And the other thing is it's a strong reaffirmance of the DMCA. And I really encourage any online services that host or have user-generated content posted on their website to, if it behooves you to make sure that you're DMCA compliant. That means you register an agent with the Copyright Office. You have a policy, DMCA policy that deals with repeat infringers. You promptly take down, remove materials after a takedown notice. Because if you do that, then you're going to have the benefits of the DMCA protections, and if you don't, then you don't have the safe harbor protections, and that could lead to a lot of liability.
Yeah, and just so everybody knows what we're talking about here, that's user-generated content, stuff that your listeners are posting on your website where you let them make music videos or post other things on your website where you've got no control over what they're posting. But be careful that you're not encouraging them to make any sort of infringement. Don't say, hey, take any song that we're playing on our radio station, make a music video of it, and we'll give a prize to the best one, because you're encouraging people to put music and video together, which you need rights for directly from the record companies and the underlying music publishers to put that together with a video. So if you're encouraging people by giving them a prize, if they post it, hey, you just encourage them and you're outside the safe harbor that you get under this DMCA.
Who's got a question?
Oh,
I see. My boss. Diana Fleming. There's somebody, I think, actually, there's somebody in the back. Can you hang on?
Is this
I hate
on?
to say that. No?
Oh, I had a question. Yeah.
Great, yeah, take care of that. And identify yourself if you don't mind.
Scott Fleischer from TuneIn Radio. You had mentioned that without geo-blocking, that can cause problems, obviously, regarding royalties. However, I think we have to face it that internet radio is a global medium. So this is a question for any of you. And do you see a global solution to the royalties ever coming? Is it something worth pursuing? And you were laughing. So, yeah, I mean, it's a global medium. So is that ever going to be solved?
I think lots of people would like to have that issue addressed. It's extremely complicated. Copyright is traditionally a territorial, which is a legal word meaning that it's just specific from country to country, and you go to the UK and you've got a system that looks sort of like ours, but is a lot different in lots of ways, including the fact that there's not a statutory license, right? And the rates are different from country to country. The way that royalties are divided up are different from country to country, and you frankly got different institutions that have been around for anywhere from a few years to decades, that are players in the space. So it's extremely complicated, but I don't think anyone would disagree that it's more complicated than we wish it would be in the internet context.
If I can just add on, I mean, to be blunt, it's a mess dealing with the international licensing. It really is. There's just so many different rights involved. There's different players. There's different royalties at issue. The royalty rates differ. How they base their royalty rates all differ country by country. And yes, to the questioner, my hope is that there is a global one-stop shop where you can do it, and it's just going to make it a lot easier, and it's going to inure to the benefit of the record labels and the artists, because I think there are webcasters that really do want to pay. It's just that it's so difficult, especially a lot of webcasters don't have an in-house legal staff, and it gets very expensive to make sure you secure all rights internationally.
I'm getting alarmed. The police are coming. We may be rated. Diana Fleming.
Yes, thank you. I asked a question earlier about building a mobile version of a website, and I know this is gray legal area because it probably hasn't been figured out yet. But if you have a website and you want to build a mobile version of that, and you're moving into a whole new set of regulations versus what you have that pertains to the internet, what particular area or concern should I have relative to telephone and regulations? Because I'm kind of combining the two.
I'm not sure that there really is a whole new set of regulations that you're facing when you're putting your app on a mobile platform, but there will be a whole new set of privacy concerns that every webcaster should be thinking about when you're looking at questions like geo-targeting, identifiable IP addresses. In fact, Congress has been very active in coming up with a whole new set of regulations on that. There have been lots of suits against existing providers, including Pandora and virtually anybody else, Apple, anybody else who's providing any sort of geo-targeting, any sort of information about people who have applications. You got to make sure that there's lots of disclosures to your users, that they know what you're doing with the information that you collect. They got to know that you're collecting the information for you to be safe. And even then, we'll see what Congress comes up with, some of the privacy regulations that they're considering right now. But for the most part, the most important thing is disclosure in plain English about the information you're collecting and what you're going to do about it.
I love it when lawyers talk about plain English. And these guys can all do that.
On a mobile app, if you put one of those long disclaimers that's 53 pages
iTunes,
of legalese, you
login.
can't read it.
Oh, God, Lord. Forever. One last question.
Yeah, this question's for Colin. And maybe Angus could chime in on this too. How much discussion is there inside of Sound Exchange, and are there any dissenting voices that feel the rates are too high and are actually stifling growth and investment in the space?
Can we get a court reporter on this one?
Yeah.
You want to show hands and?
I mean, so right now, honestly, there's not a lot of discussion about webcasting rates because we went through that fight 3 years ago. What we see at Sound Exchange is the industry growing. I mean, we see a lot of growth, and that's what we hear about today, and that's what we saw in Kurt's presentation. And yeah, I mean, it's not, necessarily easy, and certainly there are challenges as there are in any business, but we feel like it's our obligation to maximize the value of music. And the rates, like I said, the rates that are set now were negotiated. They were the product of negotiation for the most part. If there's not a settlement, we don't have the ability to say no, then the rates are litigated, and each side puts on their case before the copyright royalty judges, and the rates are adopted, and they are what they are. But we see growth. I mean, and we see lots of we look at the industry now, and it's sort of still nascent, and like I looked at the the revenues per listener hour that Kurt put up, and they were sort of shocking because I think there's just so much potential here that has yet to be exploited.
If I could just add in, so I agree with Colin that there is certainly growth. I mean, Sound Exchange releases its information every year. But if you look, the growth is primarily from one service, and that's Pandora. And a lot of the other services have just been relatively flat with the current rates. So I just want to add that little footnote.
And Pandora is paying rates at essentially 1/2 of what broadcasters are paying for their streams. So,
And that's a whole other panel.
and, I love that chart that Kurt had. Yeah.
That's a whole other panel. Talk to my lawyer. I'd like to thank Colin Rushing, David Oxenford, Angus McDonald.